Illinois. I work in the General Civil Liberties Office. Our office covers a lot of issues, including overlap, or we get to work together. Yeah, my colleagues get to work together anyway with and I'm in the General Civil Liberties Office, which focuses primarily on First Amendment issues, police practices, and national security issues. We pick up other work sometimes too, with religious freedom and counters to that too. So it's a really great kind of broad practice, and I'm excited to talk to you all about it.
Hi, I'm Laura Miller. I'm from Foot for Quality. You can't really tell what we do from our name. We're a disability rights organization. We have a similar organization in every state in the country. They're generally called like Disability Rights Wisconsin, Disability Rights Michigan, but we just have a different name. And we all receive federal funds through various acts to protect the rights of people with disabilities. And I think the unique thing about our organizations is the problem the person is having has to in some way be related to their disability. So we don't do divorce for people with disabilities or bankruptcy or any general civil work. So we focus on employment discrimination, community integration, restoration of guardianship, abuse and neglect of people with disabilities, special education, a range of other things. I'm the managing attorney in the civil rights team, so I actually, it's a fun job because I do supervise the individual casework, and then I work on most of our class actions, and so I can sort of, see how the individual problems evolve into a class action.
No, that's We'll do that towards the end. Yeah, that sounds great. So if you just want to keep a
okay. Well, if you get nothing else out of these remarks, you should pay attention to your printer when it says it is running out of ink. These are nice remarks. So hopefully I can read it. It keeps sending me that message, and I said, oh well, it seems to still be working. So I guess the first place to start is what is impact litigation, and the way I think of it, and Karen, I think you may have other thoughts on it, but these are cases either to enforce existing law or to create and enforce a new interpretation of existing law, a broader interpretation, pushing the envelope. But whatever that goal is, the thing that all impact litigation I think have in common is that you're trying to help a larger group of people, not just one person. But there are, I think, many different kinds of impact litigation. I think typically people think of impact litigation as class actions, but there are other ways. There are organizational cases, in other words, you bring a case on behalf of a specific organization. There are individual cases, and then there's sort of what I call a flurry of similar individual cases that all sort of make the same point. So before talking about our caseload, I just thought maybe I'd talk a little bit about the strengths and weaknesses of each model. I was going to ask people for their ideas, but Brian told me that it's more relaxing if the speaker speaks and the audience gets these lunch, which makes sense. So I think with class actions, the big advantage of them is that you can achieve, very broad systemic relief, and then there's not a big question about who it covers, it's the members of the class, as the court has certified the class. I've done a lot of class actions. I would say the downside of them is you need to find representative plaintiffs. And that sounds easy because you're bringing a case because a lot of people are having the same problem. But it can be difficult to find people who are willing to participate, who are easy to reach, who don't have any bad acts in their scenario. So that can be kind of time consuming. And then, of course, you need to get the class certified, usually over the opposition of the defendant, and that can be very time consuming. It's usually a year, I would say. And sometimes we have discovery about class certification. So the judge grants limited discovery over things like typicality, commonality, and so forth. And then I would say the final problem is that if the case settles, you have to have a fairness hearing. And the first two class actions I did, the fairness hearing was just swimmingly, and I got really, did not understand how seriously they can go awry, which I learned later in a case that was for quality. So then sometimes we've brought organizational cases where instead of representing a class, you might represent an organization, like a membership organization that represents people with disabilities, or a service organization that serves people with disabilities. And again, it's a good way of achieving broad systemic relief, and it's generally quicker than a class action. But it does get downsides too. The standard for organizational standing is very complicated. Like, if you're a membership organization, you can have representative standing, like you're representing the people who are members. But then if you're not a membership organization, you can still say, well, it injures our organization because we have to spend X amount of time answering calls from, for example, people who are having transportation problems. So you have to meet these standards, and they're just kind of complicated. Another issue is that you, instead of working with a typical client, you're working with the board of the membership, of the organization. And, that can be challenging for those of you who have worked with boards, know that. Another thing to think about is just bringing an individual case. And that can sometimes establish a new rule of law or a different interpretation of an existing rule. They're easy to bring. You only have one client to represent. I think the problem with that is that sometimes it doesn't bring the systemic change that you expect. We brought several cases on behalf of young people who were aging out of this very intensive program for children with complex medical issues. So these were children who had respirators and G-tubes and so forth, and they got very robust services as children. And then when they turned 21, they were told by the state, oh, okay, well, now you turn 21, you'll just do just fine on about a quarter of the services. So we brought cases as the Prairie State, and we would keep winning these cases, and we kept thinking, okay, they're going to get the message and change this for everyone, but that actually didn't happen. And so then another lawyer took that body of law, brought a class action, and got the relief for everybody. So that was an instance where we thought the individual case would achieve broad relief, but it didn't. And then the final way that I can think of is just by bringing a flurry of similar cases, like, filing lots of cases against the Department of Rehabilitation Services for cutting people's services in the hopes that they, as a result of our winning a bunch of these, will change their interpretation of certain regulations that they have. And again, that's a little bit hit or miss. Sometimes works, sometimes it does not. And when it doesn't, it's for the same reasons as the individual case, that notwithstanding the plaintiff's prevailing in a bunch of cases, the agency doesn't change its practices. So we actually have 5 class actions going on right now. Fortunately, we have co-counsel on all of them because that's a pretty hefty class action load for a mid-sized organization like we are. So much of our work is in the community integration area, and I wanted to talk about this just because this is something that's so important and that I actually knew nothing about until I came to Equip for Quality, even though I had worked with people with disabilities before arriving there. So basically what this means is that we try to prevent people from going into institutions, and then we try to help them get out if they are in an institution. And, well, why is this important? because most people don't like living in institutions. That's a simple reason. You can't decide who your roommates are, you don't have much privacy, you can't decorate your physical space, you can't hire and fire people who are helping you, you can't sort of freely participate in the life of the community, you can't choose your own hobbies, you can't decide when to wake up and go to sleep, you can't decide when to eat, you can't decide what to eat, you can't freely have guests over, very difficult to have a job when you're in the institution, and then generally institutions have higher incidence of neglect and abuse, although not everyone would agree with that. And really all the research has shown that the benefits of community living apply to people regardless of their type or severity of disability. So you'll hear some people saying, oh, this person is too disabled to live in the community, but really anyone can live in the community with proper supports and services in the same way that people can age in place if they have proper supports and services. So the law on community integration is actually quite good, and it's evolved since the 1970s in fairly positive ways. And please interrupt me if you have questions, because I don't want to. Feel free to interrupt. So the passage of the Rehabilitation Act, which I think was in 1974, it prohibits discrimination against people with disabilities by recipients of federal funds, and then it has this nice thread that requires services to be offered in the most integrated or least restrictive setting. And then there were all these like good cases like Pennhurst, which law students typically read for its procedural holdings, but it's a very good case, and it caused this huge institution in Pennsylvania to be closed. There's a bunch of similar cases around the country. And then in the early 80s, Congress authorized the waiver program, which means states can use their Medicaid money not just to pay for institutions, but also for small settings in the community. So that was a big change. And then in 1990, the ADA, with Americans with Disabilities Act, was passed, and that found that the isolation, and segregation of people with disabilities is a form of discrimination, even though there's no sort of group to compare them to, because there is no other institutionalized group. And then in 1999, the Supreme Court decided the case Olmstead, which just affirmed that unwarranted institutionalization is a form of discrimination. And I think most notable for today's purposes, that was not a class action that was brought on behalf of two women in Georgia who the staff in their institution believed that they could live in the community, but the state did not make any community placements available. And that case has had a huge impact, even though it was not a class action. And most states have made really great progress over the last 30 to 40 years in getting people out of institutions. So, if you look at, just look at the Midwest, Wisconsin, Michigan, Indiana, all have made tons of progress. And in fact, Michigan and Indiana are institution-free for people with developmental disabilities, which is great. And so then we come to Illinois. And I would have to say that Illinois just sort of ignored all these changes and ignored the legal changes, but also ignored all the literature in the field that documented, every person from Pennhurst was followed and all the gains were documented. And so Illinois, both from sort of a, professional perspective and from a legal perspective, just sort of carried on with things as normal and did not make significant changes in terms of the number of people who were served in large institutions. So we started looking at this in the early 2000s, and we just saw like tens of thousands of people institutionalized, and it was really disturbing, especially since we're very in touch with all the other states because we have our sister agencies in all these other states, and we just saw, how dramatically behind Illinois was. And so we visited, I would say, more than 200 institutions of various types. Nursing homes, psychiatric nursing homes, facilities for people with developmental disabilities. And then, you know, we talked to many, many people with disabilities and many, many guardians of people with disabilities. And it was very clear that people wanted something other than these large institutions, which range in size generally from 16 people to thousands of people. We filed 3 class actions, fairly close in time, actually. We thought about doing one gigantic class action, but that seemed very unwieldy. And in fact, these smaller class actions have been somewhat unwieldy themselves. One, and I should say that all of these are filed with the ACLU, and in each of them we have a law firm at least one law firm working with us. We filed one lawsuit. It was William V. Quinn, and this was filed on behalf of people who live in institutes for mental disease. And this is, I think it's a federal term, it's a Medicaid term. It's nursing homes where more than 50% of the people who live there have a diagnosis, primary diagnosis of mental illness. And these facilities get no federal funding, they're totally state paid. We visited all of them. About 4,000 people, I think, lived in them when we started. I mean, they are so horrible. Like, I used to go in and I would think, like, what if I had to spend one night here? Like, how terrible that would be. And I remember in one, Rainbow Beach, like, the women would say that they would sleep with like one eye open all night. They never really got a good night's sleep because they were so fearful of sexual assault by either staff or other residents. So not nice places. They're not even sort of physically nice. Sadly, I met with a client there who had been a client of mine when he was a child, and he was now, I don't know how he's in his 20s, and we asked him how the food was. He said, the food's good, and then he later said, oh yeah, the place is filled with bats and bugs, you know, so they're just not even, you know, physically acceptable. We have class certified, and it's, you have to be 18 or older and live in one of these IMDs. And they're privately run, but they are not Medicaid, but they're publicly funded. You know, so the Illinois Department of Healthcare and Family Services pays for people to live there. And, you know, the other thing I would say, just apart from their unpleasantness, I mean, there's just really very little hope for recovery in any of these places because they're dark, they're depressing. I mean, I would think, I'm not saying this to be funny, but I think people would develop depression even if they did not have depression when they went in. And there's very little to do. You know, they have the required stretching and current events classes, but there's not a great program. There's not a great rehabilitation program. People see a psychiatrist, you know, once a month to check on side effects. There was a psychiatrist who served a ton of these nursing homes named Michael Reinstein. And he was like, you know, he probably spent an average 30 seconds with people. And it turned out he was being paid by a pharmaceutical company to prescribe a certain drug, and he could get paid based on how many people he prescribed it to. And so it ended up that he prescribed it inappropriately to hundreds and hundreds of people, and he's been indicted. And fortunately, he's no longer serving people in IMDs. So under this consent decree, I won't go into detail because Dan's already talking when I should be done. But so people over the next 5 years, if you want to move out, basically, you can move out, although you do have to have an evaluation that finds you able to live in the community. And most people, the default placement is permanent supportive housing, which is your own apartment. And then in your own apartment, you just get the level of service you need. So if that's an ACT team, that's a very high level of help, that means, people are available for you 24 hours a day. If that's what you need, that's what you get. If you need something much more occasional, that's fine too. People get bridge subsidies to move into an apartment, and so there's many benefits that allow people to move out of the IMDs. The front door of the IMDs has not yet been closed, but if you do move in, even now, you're still a class member, and you have this right to move out and to get these various benefits. And then we also filed this case on behalf of people with developmental disabilities, which I work on a ton. And that was filed on behalf of about 6,000 people. They live in this thing called ICFDs, intermediate care facilities for people with developmental disabilities. And that also is the Medicaid term. And those ranges, these are all private, but again, they receive funding from the state, and for ICFDs, the federal government pays half. So these are, they're all funded by either state or federal money. And, we argue that this was too restrictive a placement, and people should be entitled to live in the community. We had 5 nationally recognized expert witnesses, and we did tons of trial preparation, very close to the trial date, which is often when the case is settled. We settled the case, and this was the fairness hearing from hell. This was in July of 2009. We had this great consent decree, which didn't force anyone to leave an ICFDD, but allowed everyone to, and everyone would be evaluated, and then they could choose whether they wanted to or not. And so we arrived at court, and there were over 2,000 guardians opposing the consent decree. So they had to use the ceremonial courtroom. Then they had to set up a separate courtroom with a camera. And the judge, who had the day before issued a ruling basically saying the consent decree is fine because no one has to move, listened to all these people, many of whom were judges and lawyers who had relatives in large institutions, and the judge did a complete turnaround. I can talk about it more freely since he's no longer on the bench, and said that not only was he not approving the fairness, our consent decree, which normally you would just go back and tinker with the consent decree, he was decertifying our class. So we now had 9 clients. So then we finally reached another consent decree, this time working with the lawyers who represented the guardians who opposed this consent decree. And it was very interesting because there were no people with disabilities living in ICFDs who said they wanted to stay. It was only guardians saying that they wanted their loved one to stay. My favorite one was a lawyer who stood up there and said, very proudly, I visit my brother once a year, and I know that he really loves Beverly Farms. He's in Illinois, he could only make it down once a year. So we did reach a consent decree, not as good as the first one, but still quite good. So it basically allows anyone in an ICFDD who chooses to leave, to leave. The difference is that in the previous one, everyone is evaluated, and if you didn't oppose leaving, you would be moved out. Here, only people who want to be evaluated are evaluated, and then only people who affirmatively request to leave. And we had some issues with ICFDs pressuring people to, oh, you don't want to leave. And told one guy who does want to leave, they said, oh, you can't leave here because no one else would take you, which was sad that they would say that to someone who lives there. And then some other important features are the state has to develop the capacity to serve people in the community. So if people want to leave and live in small, group homes or apartments or whatever, the state has to develop the capacity. And probably the most important thing is that we negotiated that there's no legislative contingency, and we've been working on this quite feverishly over the last 2 weeks, because as you know, there's a budget impasse, and we're saying that, well, no legislative contingency, you can't point to a budget impasse or a budget problem, you still have to fund this consent decree. So basically, over this 6-year period, anyone who wants to leave an ICFTD can leave. And then also, there's 3,000 new slots, for want of a better word, for people living at home and need additional help. They're generally living with their parents. Their parents are getting older, so they need to either move to some other place or get services in the home. So there's 3,000 new slots for those individuals. And then there's also unlimited number of services for people in crisis. So if someone becomes homeless, or their parents die, or they're being abused and neglected, whatever the crisis is, those people actually have to be served within 72 hours. So there's a lot of benefits. In the decree, we're still working on some of the more nuanced things, making sure that people have a meaningful day, like they don't just go to a sheltered workshop and sort of leave their volunteer or have employment or recreation. And we're also working to make sure that people have their own bedrooms in these smaller homes, and also that if they want to live with, 2 roommates, they're not forced to live with 5 people or 6 people. Actually, these small group homes under state law can be up to 8 people, but we argue that people, under the decree, people are entitled to have the size of home they want. Just quickly, we have another consent decree that is for people who live in just conventional nursing homes in Cook County, and again, who want to move out. There also has a consent decree that allows people to move out, and they're provided assistance with getting housing services. And then we also have 2 class actions for people in the criminal justice system, both which I've been working on. One is on behalf of people who are deaf, who are not getting sign language interpreters, they're not getting appropriate, assistive technology, and because of this, they really are suffering, far beyond what someone should experience in a prison. So people are not getting appropriate medical care because they can't communicate with a doctor. They're not allowed, they can't really go to religious services, they can't participate in vocational programs. So we did stay our discovery because we thought it would settle, because we thought this is so straightforward. Small group of people, not that many deaths in our hearing people. Prison, what they need is very clear, but anyway, it didn't settle. So we are waiting for the judge to rule on the Department of Corrections motion for summary judgment and our motion for class certification. And then we also have a class action much larger on behalf of people with mental illness in prisons. That really disturbing facts in this case, and very disturbing to talk to people with mental illness who live in the Illinois prison system. There's just a dearth of services, and people are treated very punitively and punished for symptoms of their mental illness. They stay in prison much longer because of symptoms of their mental illness, sometimes even incurring new convictions. There's one guy who was supposed to be in there 7 years, and his sentence ended up being 99 years because he was prosecuted like if he was fit by the guard when he was not, being given any services. So it's very disturbing. It's sort of one of those things that you would say, oh, it doesn't happen in the United States, but it does. And the guys are just really, it's just really sad, talking to people who are acutely psychotic, suicidal, and just not getting help. It's sort of like, if you can imagine, the worst state of your own mental health and replicating it every day of the year with no help at all. And lots of these guys are in segregation. So that means they're out of their cell only 1 hour a day. So, that also is being litigated. We have, we thought that was going to settle too. The Department of Corrections agreed to hire an expert. We thought that the expert report would lead to settlement. There was an excellent report, but it has not led to settlement. And so we are continuing to litigate the case. And so that's our docket of class action.
Good to hear it from the other side, because we have the class certification period.
Oh, yeah.
We're,
Yeah, it was the worst day of everyone's career.
yes, that's what it sounded like. I unfortunately don't get to work on those particular cases, but all of our office, everyone is always working on impact litigation. We don't have a docket of any direct services at all. The two main kinds of cases that we take on are first cases that are challenging the law, and because we think the law is unconstitutional. And those cases we can represent an individual. Sometimes we represent, the last couple of times we've done it, we've represented the ACLU and its membership organization and used a lawsuit to challenge a specific law. So, for example, the last big case that we did was a challenge to the Illinois Eavesdropping Act, which at the time prohibited people from audio and video recording police officers. So it was illegal in Illinois to do the cop watch videos that have become so prevalent, and I think are making such a change in our perceptions of police officers. It's not changing me, but I think it's waking people up around the country, which is a good thing. So we brought a lawsuit on behalf of the ACLU saying that we want to be able to operate a cop watch program and challenge the Eavesdropping Act because it prohibited it. We argued that you have a right to record police officers and other public officials in public in the course of their duties, and we were successful in the Seventh Circuit. Since then, the Eavesdropping Act has been revised, and it reflects that change. So that's one thing. Let's stand out of my impact litigation. Because, yeah, challenging. Yeah. So we did that case with Sidley Austin, and we all do all of our cases, I should say, with firms in town. So I know that a lot of you are headed that direction after law. There are plenty of opportunities to work with us and other not-for-profits, and you're in with firms later on. The other kind of case is similar to what Laura was talking about, which is the impact cases that impact large groups of people. They're challenging a policy or the way that the government is treating large groups of people. And the example that I want to talk about today is that we have a challenge against the Chicago Police Department for the way that they deploy police officers throughout the city. I'm going to step back before I get into the back of the case, because I'm with law students. I'm going to nerd out on you a little bit and talk to you about kind of the background of the law that we're using to do this challenge. So in 2001, the Supreme Court took on a case called Sandoval. And it's one of those terrible cases that is mostly about non-substantive issues which had a tremendous and terrible impact on public interest attorneys' ability to bring causes of action. Sandoval was a challenge under Title VI of the Civil Rights Act and regulations that helped to enforce the Civil Rights Act that created a prohibition on disparate impact and programs that received government funds. So I'm going to unpack that a little bit. So we have Title VI. The Department of Justice writes regulations for it, saying if we're giving out money to local governments, they have to follow these regulations. And part of the regulation says that we're not just focused on when people intentionally discriminate. We also don't want our government entities to have policies or practices that have a disparate impact on the basis of race. And that means you can have a neutral policy that on its face doesn't say race, but by the time it gets down to being being used, it has a tremendous impact on the populations that are like living under that policy. The kind of typical example of this is there are a lot of employment discrimination cases that under Title VII that use this theory of litigation. And maybe you'll have a regulation at a workplace that says you've got to lift 50 pounds in order to do the job. No one ever actually has to lift 50 pounds to do the job, but it has a disparate impact on women because there are fewer women who can get to 50 pounds lifted. And so if the intention of the law was to break down barriers that were there unnecessarily, because the way that these cases go is that you have a policy or practice, you show it has a discriminatory impact, the government then has to say whether or not there's some reason for the law, despite the discriminatory impact, and then the burden shifts back to the plaintiff to show that there's some alternate thing that you can do, or alternate policy that you can have that won't result in discrimination. It's an incredibly powerful tool because as we've shifted over time in our use of the Civil Rights Act, people are much more sneaky about being discriminatory, for one. It can be really difficult to find the direct evidence that you need to put on a case for just flat out discrimination. And then it also gets at cases where there's implicit bias. That's a theory that people have been really focusing on in employment cases for years. So, for example, there's a case that, before I came to the ACLU, I worked on, that Judge Posner reviewed how traders would set up teams, and the teams were selected by the person who was in leadership, and they would pretty much uniformly select other people that looked like him. So it meant that the black employees who were working there at Merrill Lynch, they weren't getting the kind of opportunities they needed to rise, despite the fact that they were just as qualified as everyone else. It was that, the decisions were, they were operating under a principle where they gave people too much discretion, implicit bias set in, and people were excluded from employment opportunities. That issue comes up in things like traffic stops, too. We have studies in Illinois showing that police officers are more likely to, everybody violates the traffic laws. Like, that's a given. 95% of people, when you're out driving, probably 98% of the time for me, you violate the traffic law somehow or another, and then, so people are getting pulled over kind of at random. The problem is that we don't just use traffic laws to enforce traffic laws, we use it as a form of drug investigation. So once people are pulled over, we have data in Illinois showing that police officers are more likely to ask African Americans, Latinos, to search their car for a consent search. But it's about 2.5 times more likely they'll do the ask. It's about double likely that the white people who they ask for consent search actually have contraband. So the way that the implicit bias works there is that there's somehow the officer is substituting race for evidence of criminality. And they're doing it in a way that leads them down the wrong path because they're more often wrong when they do that. So there's all this kind of litigation that's around this form of action. And in 2001, the Supreme Court held that you could no longer bring, as a private citizen, a private right of action under the regulations under Title VI. So everyone was sort of devastated. I was in law school at the time. I remember everybody trying to regroup. What are we going to do next? Here in Illinois, long before I started working at the ACLU, they put together a state law to replicate the same protections that the Title VI once allowed. So we have a disparate impact cause of action in Illinois, which requires, it's not about federal funding, it's not about that piece of it's now gone. It's a private right of action under state law that allows you to challenge disparate impact on the basis of race and gender, a national origin if it's a government policy or procedure. Very sadly, very devastatingly, we are one of 2 states that have this. So it's an amazing tool for people who are practicing here, but nobody else gets to do it. It's still available in employment statutes and other statutes, and the Department of Justice can use it too. So when they're doing consent decrees with states, with cities across the country, you'll see it incorporated there. But we're one of the few places that has this tool. So one of the ways that we use the tool in our office is to challenge the way that police are deployed throughout the city of Chicago. So the city's known for years that there are more police services available in white neighborhoods than in black and brown neighborhoods. It's been more than 25 years, we're closing in on 30 years, since they've realigned how they deploy police officers who are working beats. So the beat officers who know neighborhoods, who know the areas, they've not realigned that in about 30 years. As early as the 90s, there are studies that show that the number of officers who are assigned to districts weren't in proportion with the number of 911 calls or the amount of serious violent crime in the neighborhood. So and proportionally, there were more police officers in white neighborhoods compared to the number of 911 calls and crime than there are in black and brown communities. Since then, newspapers have reported, based on confidential sources from OEMC, for the Office of Emergency Management, it's the 911 Center here in Chicago, that minority communities were waiting far longer for a response to the 911 calls. One measure of the 911 response that was available at the beginning of our lawsuit was that the 911 Center would report how often it would happen if there was no police officer at all available to respond to a priority 1 call. And priority 1 calls are when someone's life or property are in danger. So you make a call, somebody's trying to get to your house, and this is a measure of how many times there's no officer to send at all. And the reason that there'd be no officer to send is they weren't sending police officers across district lines. If you got a call in your district, there were officers available the next district over. At the time that we filed the lawsuit, they weren't crossing. You had to wait. So in a time period of January 2009 to October 2010, which is what the newspapers were able to get a hold of, this happened 17 times in Town Hall, which is a white neighborhood, which comprises part of Lincoln Park. And in Chicago lawn, it happened 885 times. So we also learned that they don't measure very much. This is part of one of the problems that we're facing is that they measure the amount of time between when they get the call and when they dispatch officers. They don't measure how long it takes for someone to actually arrive on the scene, which if you think about that, it's kind of shocking. Most other cities are publicizing those numbers all the time. And we learned that we do have the dispatch time. And we learned that the average dispatch time in white neighborhoods versus minority neighborhoods is really, it's disparate too. So in Lincoln Foster, which is up in like the Lincoln Square neighborhood, on average it was taking 2 minutes and 19 seconds to send an officer. In Pilsen, it was 4 minutes and 51 seconds. In Little Village, 5 minutes and 25 seconds. And Grand Crossing, 8 minutes and 48 seconds. And these are the priority 1 calls, that somebody's life or property is in danger. So we were aware that this was generally an issue. We've been researching it, considering trying to do something about it for a number of years. And around that time, there was a community group in Austin that started attending police board meetings, speaking out about the issue. We reached out to them, had a couple of meetings, and they agreed to be our clients in a challenge to be on this. We also represent the ACLU of Illinois and our members, because we have members in every police district in the city. And we brought a disparate impact challenge, saying that the policy of how they deploy police officers is having a disparate impact on minority communities as measured by how long it takes to to get someone to respond when you're in an emergency. And what we're hoping and what our goals are is that we think that police officers, there should be more police officers who are on the beat, who are permanently assigned to these communities, who are available to respond to 911 calls. Instead, I mean, you may be aware of like violence reduction initiatives. We've talked about a lot in the newspaper. It's basically flooding hotspots with police officers who aren't typically assigned to the community and who often are, their assignment, it doesn't include answering 911 calls. So we're concerned about that. We think that it's antithetical to principles of community policing, and we're hopeful that this lawsuit is going to make a shift in the policy in the way that we're, and of course for discovery, we did not provide a motion to dismiss, took an appeal of that decision, came back down. So this is one of those cases that's going to take a while because there's just a lot of procedure going on. We anticipate, I don't even know how much more discovery. We're in the midst of it now. Our Philly interns and fellows, they did a great job of doing the doc review for us this summer on that, and they've been really integral to our work. So that's kind of the example that you know we've got on this part of the docket. We've got other cases too. I'm happy to answer any questions or to talk about our has, how to get some public interest.
Could you share just briefly, for a couple minutes each of you, any recommendations you may have for somebody who wants to go into this area of law?
Yeah, where do you go?
Well, don't have a huge number of material needs.
Very right.
Well, I actually, it was interesting because I actually started at a large law firm in New York, and well, it's now Cat Nugent. It was Roseman Coleman, Lewis and Coleman. Okay, at that time, but now it's Cat. So I worked there for 2 years, and then I became a public defender. So I had a dramatic drop in income, but really it was fine. You know, it was doable. You know, I don't know. My path was sort of unusual, I guess, because I started in a large law firm. But
Any classes or experiences or, you know, things to do practical kind of things to kind of put under your belt to prepare and uniquely stand out, I guess, as somebody.
when you're applying.
Yeah.
You know, we just look at people, you know, who have shown commitment to public interest, who have taken advantage of opportunities, whether they're paid or volunteer during law school in the summer. And, you know, it doesn't necessarily have to be specifically on the, you know, topic of the agency you're applying for, but then I think it's good to connect it in some way, like if you've done work in domestic violence and now you want to shift to doing landlord-tenant, you know, I think it's good to say, well, you know, when I worked on domestic violence issues, I saw that, you know, housing was a huge issue for people and contributed to unstable living situations, and that sort of has created my interest in housing, and now I'm applying to the Lawyers Committee for better housing. So I think we just generally look for people who have that commitment to public interest. In terms of classes, I know that one class that I just deeply regret not taking is like a 1983 class or a civil rights litigation class, because it's just a hard area of law and very hard to master on your own. So something like that is offered in your law school, or poverty law or something like that. I just think it's really helpful in practice. I mean, you know, and mostly, you know, I did not love law school, I have to confess. I really loved being a lawyer, but I did not love law school. And I went to University of Chicago, and at that time it was just, you know, there was very little in terms of classes that were focused on public interest, but there was actually a 1983 class, and I did not take it.
I would say, you you know, when we do hiring, we hire for both people who are straight out of law school for fellowship positions, and we also hire people who have spent some time in a firm. So it's not, nobody's cut out when we get the applications in. But the things that stand out to us are, you know, have you been doing public interest summers? Have you done pro bono work when you're at the firm? And that's the way that you build your resume to show that you have a commitment, I think. No real substitute for it. I worked at a law firm in New York before. Kind of, my career path was I graduated from law school. I worked at Sarah Gottlieb in New York. I did a federal clerkship to get out of there, and then I moved back to Chicago because I'm from Southern Illinois. I wanted to be, you know, back in the Midwest, and worked for a couple of years at an employment law firm that did class action work, and then switched over to the ACLU. I think there are a lot of paths to get into it. You just have to kind of be prepared to move around and be flexible. There's a lot of good work to do in the city and other cities. This is helpful. I think it's really good training. I agree that taking 1983 is helpful. I think that court, if you're going to end up practicing in Fed court, is an absolute must. I really wish I'd taken First Amendment.
I took First Amendment.
But like, you know, I don't know, like it just it didn't fit my schedule or something. And now like new issues pop up, and I'm like going back to the textbooks because it's funny, like you don't have the grounding. It's hard to read through stuff sometimes. I think I figured it out now, but like in the first couple of years, what's this? You know, all those standards.
One thing I would really emphasize is the importance of the cover letter. It doesn't have to be long, but you have to, you know, we're all going through lots of applications, and you might have a good resume, but you have to make the link for us. Like, why that good resume? Okay, that looks like a really intelligent and thoughtful person, but why do they want to work here? You know, what led them to a bit more quality? So I think that, you know, you don't want to make it a tome because people don't have time to read two-page single-spaced letter. But, you know, make that jump for us, why you want to be there and why, you know, what you've done up till this point helps to prepare you for working at whatever agency you're applying to.
If you're coming in from, if you're applying in a different city, we get a lot of applications from people who are in New York. And a lot of times I'm like, why on earth do they want to come to Chicago? Like, are they going to leave in 15 minutes? And then later I find out that they've got family members here or they have a reason to be here. I feel like that's got to be the cover letter. There are people that I'm like, really, what is the deal? And you don't want someone to think, what's the deal when they're looking at your resume. I mean, I'm not saying you're going to get cut out or you won't get an interview if you're at the top of the list, but it helps.
And I also hate to say this, but I think if you have some connection, just use it. In other words, it's not going to get you a job, but if the stack of resumes is 400 people and, you know, your career office says, oh, someone who graduated 2 years ago works at that same place. You know, there's nothing wrong with just emailing that person and just saying, you know, I just wanted to let you know I applied for the position of staff attorney. You know, I'm 2 years behind you at Kent or something. And that person will just probably mention it to whoever's looking at resumes and say, you know, oh, I've heard good things about that person. They were in the same clinic I was in. You know, so there's nothing wrong with doing that. As I said, it's not like coincidence to get a job. You won't get a job through that, but you might just not have your resume tossed without, you know, careful consideration.
Does anybody have any quick questions? I didn't want to completely cut out that option. Well, thank you very much, both of you, all, for being here today and for giving us an insight into the work, that's important work you're doing in the community. Great.